to get them used to being consumers in a global straitjacket. So our churches are getting us ready for one world globalism, our schools are getting us ready for one world globalism, and the federal government and the state are acting in collusion to get us ready for federal globalism. Now the alternative to federal globalism is local control. All right, we're either going to have global control or we're going to have local control. And remember, it's the well-regulated militia, which is the local men of a community that are well armed and they're well supplied with first aid and food and everything they need so that when a tornado comes and wipes out the community, they can help. Or if the community next to them needs help, we go to help them. We don't go to the federal government and petition them for a subsidy or a grant. We don't go to the governor to declare a national or a statewide emergency. We help each other. The bottom line is it's the well-regulated militia at the local level that is necessary for the security of a free state. We build on that, and to the degree we build on that, we are free. We are free. And that's the only way we're going to fight this global domination is the power has to emanate from us locally. The federal government has expanded dramatically over the past 2 centuries, but it still must show that a constitutional grant of power authorizes each of its actions. This was the United States Supreme Court, John Roberts, in his decision on health care, June 2012. They still know, they know, and don't let them think that they don't know. Don't you buy into that nonsense. The lawyers know and the judges know. And if anything, they're involved in a racket. And you know what? We've got such an enterprise of racketeering going on in this country that until we stand up and confront this racketeering enterprise, they're going to continue to dominate and control. We have to arm ourselves with knowledge. So I'm not making this up. There's plenty of backup. Now, when Colorado became a state, Congress said that they retained to themselves the power to dispose of and make all needful rules and regulations respecting the territory belonging to the United States. When Colorado came in under the Enabling Act, they allowed the federal government to retain the ownership in the lands that were unappropriated. And what that means is that the federal government was acting as a trustee, holding all of those properties in trust. Now, what a trust relationship is there's a trustee and there's a beneficiary and then there's a corpus. And the corpus is the trust of the body, and that's usually what the trust holds. The trustee has a fiduciary responsibility, which means he's responsible to manage and maintain the assets or the corpus of that particular trust. That's what this provision of the Constitution is. It establishes a trust in the federal government to make needful rules and regulations respecting the territory or other property belonging to the United States. The United States was not intended to be any kind of a sovereign. It was an agent. It was merely there as a trustee. In the case of Shelby versus Valley, an 1894 case, the federal government holds territorial lands in trust for the several states to be ultimately created out of the territory. So the federal government, in all of the areas that weren't states, was trustee over the territories until the people formed a state government and came into the Union. Now, whenever the United States shall have fully executed their trusts, the municipal sovereignty of the new states will be complete throughout their respective borders, and they and the original states will be upon an equal footing in all respects whatsoever. The United States never held any municipal sovereignty, jurisdiction, or right of soil in or the territory of the new states except for temporary purposes. Let me say what I just read. The state, as a function of sovereignty, has this municipal power to govern, to a certain degree, the people, relative to the restrictions that are imposed on the government by the Colorado Bill of Rights. It's the same type of thing. The state enjoys sovereignty. The Colorado Bill of Rights operates as a restriction on that power. So the state government, in some respects, is more powerful than the federal government. Now here's the scary thing. Because the state in some respects is more powerful than the federal government, the scary thing is what happens when the federal government ends up in so many compacts and contracts with the state that the state and the federal government become indistinguishable, that they appear to be the same thing, that the state looks like an agent of the federal government. That is a complete violation of the separations of powers. That is a complete total enjoining of total power, and it is a design evinced to reduce the people under absolute despotism because the power is total and complete and there's no check on it. There's no check and balance. Understanding that the federal government doesn't enjoy municipal sovereignty of the new states, this municipal sovereignty, it doesn't have any. The federal government has no municipal sovereignty within a state. It has no business talking to me. It is not my king. It is not my sovereign. It is an agent with very limited power and very limited jurisdiction and very limited control. But to whatever degree I think otherwise, they're going to act otherwise. And that's what's been happening on our federal lands, on our public lands. Enabling acts are solemn compacts and bilateral two-way agreements that are to be performed in a timely fashion. According to the Colorado Enabling Act, listen to this. This is a really good one. Colorado Enabling Act, a solemn compact. Sale of agricultural lands. 5% of the proceeds of the sales of agricultural public lands lying within the state which shall be sold by the United States. I'm just going to stop there for a minute. Shall. Doesn't say should, doesn't say when they get around to it. It says shall. The federal government is holding those public lands in trust. They're unappropriated. They have a requirement by a solemn compact called the Enabling Act to sell those lands. To sell those lands. What happens when they sell those lands? Those lands cease, they come out of the trust corpus, they come into the state. Now the state can tax those lands, and to the degree that it can tax those lands, now we can fund our public schools. Right now there's a big cry that our public schools, we need subsidies from the federal government because we don't have enough tax base to keep our schools going. Well, the reason that we don't have any money to keep the schools going is the federal government has stopped selling the public lands, and now they've changed their policy, how they use those public lands, and they're wanting to cut off our access to those public lands entirely. They're wanting to cut off our access to the gold, the silver, the mineral resources, the timber sales. Everything about the federal lands is now being held for purposes other than what the Colorado Enabling Act requires the federal government to perform on. Well, now the state is being negligent, and they're not pushing this. The federal government is exercising a usurpation of power because they've changed their policy about, well, we're not really going to go ahead and enforce, or we're not going to comply with the Enabling Act. Well, that's a breach of contract. That's an abuse of power. That's an overreach of federal jurisdiction. But the people remain silent because we don't understand this. So the lawyers, they're not talking about it. The judges aren't talking about it. The lawmakers aren't talking about it. So everybody's being silent while this federal nose continues to creep under the tent. And oh, by the way, here comes the Homeland Security now riding in again on the Trojan horse called the BLM and the Forest Service, and they will be in our backyard if we do not stop this. You know, where do we need to engage this thing? If we engage this thing at the principal level and stand on the principle, they will be exposed as they try to go across that boundary that they can't cross lawfully, and they know it. This is the conversation that we need to be having, I think, in order to expose an agenda. Okay, the Enabling Act is the paramount law of this state, and all constitutional provisions of our fundamental state document must be consistent with it. Remember, the Enabling Act said that the Colorado Constitution shall not be repugnant with the principles of the Declaration of Independence. The Enabling Act is the supreme law of the land because it's a federal act, and it is consistent with the supremacy laws of the federal Constitution that says, this Constitution and all laws made in pursuance thereof shall be the supreme law of the land. The Colorado Enabling Act is the supreme law of the land. They have a duty and obligation to perform under the Enabling Act, and if they don't, that's a breach of fiduciary responsibility as a trustee. And if they pass a law that breaches the Enabling Act, that subsequent law is absolutely and completely void. You can't have two laws that conflict with each other. One of them's got to give. And the United States Supreme Court has already ruled that the Enabling Act is a fundamental law and paramount, cannot be altered, changed, or amended, or discarded without an act of Congress. And the Congress actually has to, what do you call it, repeal it. They can't just write another law trumping it, they got to repeal it. So until that happens, the Colorado Enabling Act trumps everything, which means that the principles of the Declaration of Independence are alive and well, and this kind of conversation is the one the government doesn't want to hear, which is why we need to have it. Okay, so
thank you for giving it.
The Journals of the Continental Congress, this is in 1780, resolved that the unappropriated lands that may be ceded or relinquished to the United States shall be disposed of for the common benefit of the United States and be settled and formed into distinct republican states, which shall become members of the federal union and have the same rights of sovereignty, freedom, and independence as the other states. Okay, so these are, again, fundamentals. State legislators are the protection, will jealously and closely watch the operations of this government and be able to resist with more effect better than any other power on earth can do. And the greatest opponents to federal government admit that state legislators to be the sure guardian of the people's liberty. We need to get a hold of our state legislature and help them to realize that their failure to interpose, their failure to nullify federal laws that are a usurpation of the power of the people is an act of treason.
He's busy giving the Secret Service more authority. I don't think he'll take our calls.
Who's that?
Steve King.
But Jared Wright, who was very, very sad that he couldn't be here, has sponsored legislation to nullify the NDAA, has sponsored legislation to go after the drone program, and is moving in a direction that we need to be moving. So we do have some light at the end of the tunnel.
What we have in our advantage is the truth. We have the principles of truth on our side. And so whatever degree that we're willing to stand for those principles is the degree that we will be empowered to stand for those principles. Okay, so the principle of Federalist Paper number 51. The power surrendered by the people is first divided into two distinct governments, okay? State and federal. And it's important to understand this distinction. So I could go on, but let's suffice it to say there's the Enabling Act, and there's the part that I just read. And some of you have seen Ken Ivory stuff. And so what I want to do here is I want to go to this Federal Land Policy Management Act, 1976. This law is in the way, and it is, I believe, completely unconstitutional and void and has not been challenged. So I'm working to put myself into a position to challenge it. Congress declares that it is the policy of the United States that public lands be retained in federal ownership unless it is determined that the disposal of a particular parcel will serve the national interest. But the Colorado Enabling Act specifically requires that the federal government sells the public land and begins to relinquish that back to the state of Colorado. We have enough federal or public lands out there that if they were being disposed of properly, we would have access to a lot more minerals. Look at today's world that we live in. Rare earth minerals, they're all out there. Forest. Let's see, where am I going to go? Here's what my concern is. If we continue to let these, the BLM and the National Forest declare these wilderness areas and to exclude us, my concern is that the federal government, we might find the federal government selling off this land to, as collateral on this national debt that is way out of control. Who's going to loan the United States money unless there's collateral backing it? And if you look through the history of banking in this world, the bankers typically will loan money to nations and use the infrastructure as collateral. This is not a conspiracy theory. This is how the banking system works. And I'm persuaded that what's happening, what we're not being told, is that the federal lands are being used as collateral. What else is funding a $16 trillion deficit, which is created out of thin air in the first place? So, again, the idea that the federal government may be cordoning off those areas, that the real objective is to think about it. Our national treasure is in our resources. And what more resources are there in Colorado? And so why is it that Colorado seems to be at the cutting edge of this sword of federal encroachment? It's very likely, and I'm not saying conclusively, but it appears to me more likely than not that it has something to do with the reserves and the national treasure that we have here in the mountains. So these are important. We need to understand the difference between legislative, concurrent, and proprietary interests. In 1958, the federal government conducted a survey of all of the lands that it owned inside the continental United States and broke it down into 2 volumes called Federal Jurisdiction over Areas Within the States. And the point of this was they wanted to know exactly what kind of power they had in the states. These are the 2 books. Now, another report was done in 1962. This is an inventory report on jurisdictional status on federal areas within the states. The reason I'm showing you this is it's hard to believe, but here it is. You're going to see it with your own eyes. This was a report. GSA has completed the 2nd comprehensive inventory of jurisdictional status of federal areas within the states. Remember, the federal government doesn't have a general municipal power within the state of Colorado. They have a interest in making rules and regulations over federal lands or lands in which it has an interest. And so they want to do an inventory, and so here it is, and here's the inventory. Right here, type of legislative jurisdiction. I don't know if you can read that, but this is type of legislative jurisdiction. Now, legislative jurisdiction is the federal Congress where it has legislative jurisdiction. What that means is they can basically do everything that the Constitution gives them the power to do. They have what they call exclusive legislative jurisdiction. And where they have exclusive legislative jurisdiction, the restraint on their power is the constitutional restraint that the Bill of Rights imposes, and the power to make rules and regulations. This term is applied when the federal government, I can't quite read that, I'll read it on here. This term is used when the federal government possesses, by whichever method acquired, all of the authority of the state, and which is the state concerned has not reserved to itself the right to exercise any of the authority concurrently with the United States, except for the right to serve civil or criminal process. Where the federal government has legislative jurisdiction, their power is pretty much total. And I'll give you an example of where they have legislative jurisdiction. Post office. When you go into a post office, you are on federal property. They have the power to arrest you, and all of their municipal laws apply in that respective jurisdiction, because that's considered no different than the District of Columbia. So when you're in the post office, you're in the District of Columbia, or you may as well be on Puerto Rico or Guam or the Mariana Islands. You're on a federal enclave within the state. All right, that's what federal and executive legislative jurisdiction. Concurrent legislative jurisdiction is where the state has said, you know what, we're going to give the federal government some jurisdiction over that area. Now, how does that happen? In Title III of the Colorado Revised Statutes, and it's right here, Title III. yeah, right here, that.